Hi, everyone. I don't know if anyone can hear me. Hello, everyone in chat. Hi. If people can let me know if you can hear me really well, that would be great. But we're going to give it a few minutes for more people to join. I do appreciate everyone joining here today for this free webinar to talk about EB-1As and EB-2 NIWs. Just as a gentle reminder for people just joining, the chat is public, right? So if you're going to be posting things about yourself, personal information and the like, it is not confidential. There will also be opportunities at the end of this webinar to have a Q&A completed. So we're happy to answer any questions that you may have. So we'll give it a few minutes. We'll get started at about 4:03. Oh, I have someone here who says that they can't hear me. People, wait, so let's see here. Now you can. Okay, now you can hear us. Or can't hear. Can't hear, okay. All right, so we'll give it like just one more minute. Okay, so we'll get started right away at 4:03. Hopefully everyone's having a great afternoon, or maybe it's still the noon or the morning or night, wherever you may be. So right before we get started, just as a reminder, I'll try to answer questions where they make sense while we're in the middle of the webinar, but for the most part, I'll be answering most of our questions via the Q&A portion of our time today. Outside of that, if there's something that's very personal, we also will give you guys the ability to reach out to us, whether it's through our socials or through email. More than happy to support any of you guys when it comes to your immigration journeys. All right, so we're at 4:03 p.m. Happy to get started. Welcome to today's webinar. It's called Stacking Your Green Card Strategy. Today's subject is really going to focus on EB-1As and EB-2 NIWs and maybe how you can utilize both to your advantage. I'm also going to touch a little bit upon like eligibility, how you can really improve your case, and maybe even invest your time in the right places to make sure that you have the strongest possible foundation in order to even approach the particular application. So that being said, just to briefly introduce myself, my name is Nicole Gunara. I am the principal immigration attorney here at Manifest Law. I have a lot of years of experience here in immigration, having held leadership positions. I was the business immigration team lead at previous organizations. I've also led a lot of multinational immigration programs, but my areas of expertise are in talent visas, in business immigration generally speaking, and also things like E1s, E2s, L1s, and other employment-related visas. Just to quickly answer your question, Richard, we are recording this particular webinar. It will be available out there on the internet, so don't worry about it. You don't have to record it yourself. It will be accessible for everyone involved. We will also have maybe a few shorts so that you can easily share a lot of this content with your friends and your family. Outside of that, Manifest Law, we like to think of ourselves as a very tech-forward immigration service provider. We also believe very strongly in radical transparency. We utilize our own software platforms and the like in order for you to collaborate with us in order to make the best and possible experience and also best possible application that goes out to USCIS or whatever government agency is associated with your application. So number one, and what I really want to focus today's conversation on, is why does strategy matter, right? Why multiple strategies rather than just one, right? Sometimes people feel like, oh, I can only approach the EB-1A. Oh, I can only approach the EB-2 NIW. Or, oh, can we do it in many different avenues or different styles? Can I apply for the same time, right? The reality is that I personally believe that you should treat immigration as if it's a kitchen stove. You should be approaching with as many pots and pans as you can, having as many dishes going at the same time, because a single track plan can really leave you exposed. If you rely on only one strategy and in only one methodology, what happens if the government decides to make that particular category unavailable? I'll give you an example. If you came in on a religious visa here to the United States and you applied for an I-360 and you only focused on getting that green card pathway through that religious occupation, right now that category is unavailable. No matter what happened and like when you got it approved, you cannot file that adjustment of status. So for people who are on R1s at the moment who only have a 5-year limit total on their statuses, they're kind of left open and very vulnerable in that moment, right? So because of this, I really tell people you need to treat immigration like a stove. The more you have going for you, the more opportunities that you open up and the more you invest into it, the better the ultimate outcome can be and the more likely that you're going to have what you're looking for. I will also note that at times, if you qualify for an NIW sooner, you can also set a priority date earlier, and I will talk a little bit more about that in a future slide. So let's talk about the fundamental differences between the two main visa types that we're going to talk about today, which is the EB-1A and the EB-2 NIW. I know many of you who are already at this webinar are very familiar with it, but I'm here to just do a very, very quick overview. The EB-1A is for individuals of extraordinary ability in the sciences, arts, education, business, or athletics. Don't feel like these categories are very restrictive. I think what I want to say is that it's if you're extraordinary in your field of endeavor and you qualify based on this criteria list, and there's a list of 10 items here for the EB-1A, then this would be a really solid pathway for you. Just to rehash it really quickly, you have to meet 3 out of these 10, and I will explain it in more detail in a separate slide. But essentially, it's receipt of nationally or internationally recognized awards, membership in associations that require outstanding achievements to join, press about you in professional or major trade publications or major media, judging others in the field or an allied field, original contributions of major significance, authorship of scholarly articles, display of work at artistic exhibitions and showcases, commercial success in the performing arts, lead critical role at distinguished organizations, and high remuneration and salary. There is a hidden 11th category called comparable evidence, where if you can prove that there's something in your field that recognizes your expertise or recognizes your extraordinary ability, you can make a really great qualified argument. A good example is if you're a medical doctor, conferences are a little bit more important in your field than, say, the generic research paper. At times, and I will tell you it's a case-by-case basis, it might make sense to make a comparable evidence argument as your third category. For the EB-2 NIW, these are for individuals who are pursuing an endeavor of national interest. And that's kind of broken down into 3 main prongs, which is that is there substantial merit to that interest, and is that project or whatever it is that you're trying to do of national importance. Second item is whether you're well positioned to advance the endeavor. And last is the benefit to the United States when they waive that job offer and labor certification requirement. So Rogerio, you're absolutely correct that the time of the visa bulletin is a really long time, but I'm here to really explain why that's kind of okay, right? Because it's all about setting the priority date. And that's the reason why today's conversation is so important, is because not a lot of people realize setting the priority date is going to be helpful because it could be absorbed by another category like the EB-1A, which doesn't have as much of a long time, right? Omar, I see that you have a question about what does well-positioned mean. I actually have a separate slide that's going to break down every single one of these things, and I'm going to explain it to you in really, pretty good detail. So hopefully it would give you some ideas here. Just as an important note, both are very different pathways. Sometimes we get a lot of inquiries from people who are like, oh, you know, I qualified for an EB-2 NIW. Can I just get an EB-1A? The answer is that even though maybe some of the evidence could be similar, they're not really the same. The arguments are very different. Remember, EB-1A is about how extraordinary you are compared to others, while the EB-2 NIW is more like, what are you doing and what are you planning to do in the United States that's of national interest? Those are very different concepts, right? So I will always tell and remind people, you can always apply for both. The government doesn't really mind that you're applying for both. If anything, they really are okay because you're going to pay them fees to process the applications anyways. The government doesn't prevent you from doing so. Getting one approved and not the other will not impact either case or existing green card cases. So key differences, right? These are just like quick compare and contrast. Eligibility standard, like it was mentioned, is sustained national, international claim at the top of your field if you're an EB-1A, extraordinary ability, rehashing that. EB-2 NIW, work must benefit the US and justify waiving the job offer. So remember that you're doing something that's going to nationally benefit the United States. Both of them don't require a labor certification, although for the EB-2 NIW, there's certain forms that need to be filled out, right? And then for employer sponsorship, both of them allow for self-petition. In particular, with the EB-2 NIW, some companies do sponsor for the EB-2 NIW. It can be petitioner-led. Evidence focus for the EB-1A is more on specific awards, publications, media, impact, judging, leadership. For EB-2 NIW, it's again proving, is your work of national importance? Is there merit? Is there a level of urgency that is involved? Of course, there's questions regarding your qualifications, but it's not to necessarily the same degree and strength as an EB-1A. And in terms of processing time, which is a really important component of this as well, the EB-1A is often faster. Premium processing is available within a 15 business day timeline. Some of you have already talked about the visa bulletin a little bit. The wait times for the EB-1A are lower. And with the EB-2 NIW, it is slower, but it is still 45 business days for premium processing, which I think is not too bad. But at the end of the day, it is longer than the EB-1A at the moment. I want to let everybody know, as a gentle reminder, you are not required to immediately seek premium processing. A lot of people file for regular processing first and upgrade later, but hopefully that was a helpful tip for everyone, because you can upgrade at a later date. You don't have to do it immediately. So when it comes to green cards, right, we want to remind everyone that not all green cards move at the same speed. Right? Your employment-based category, EB-1 or EB-2, determines when you can file the 485 or the adjustment of status. For those of you who are not in the United States, this doesn't really apply to you. However, the visa bulletin does dictate when you can finish off the green card process through consular processing. The visa bulletin, just to let everyone know, is updated monthly by the Department of State, which controls when green cards are available based on the category that you've been approved in and the country of birth, right? Emphasis on country of birth. You could be a citizen of Singapore, but if you are born in India, then you will fall under the Indian born category. I will also note to everyone who's sitting here, if you are married, think about something known as cross-chargeability. So what does that mean? If you are married to someone who is, let's say, a citizen of India, however, was born in Singapore, you can actually absorb their country of birth to your benefit, because your spouse should not be prejudiced by the wait time as you of the principal applicant, right? So the government allows you to absorb your spouse's country of birth, but not your child's, okay? So the next thing that I want to note is that the backlogs exist when demand exceeds annual limits. So the reason why this visa bulletin even exists in the first place is because the government is limited in how many visas that they can issue, or really how many green cards that they can issue per year. And they're divided by individual country quotas. I will let you know that the backlogs are the heaviest for individuals who are born in India or born in China. Generally speaking, EB-1 typically moves faster than EB-2, but both categories can backlog. The reason why EB-1 can typically move faster is that historically it's a lower volume category, but on top of that, it's a first preference category. So some call outs, right? Specifically for Indian and China born nationals, right? Here's just like a really quick chart for you guys to refer to. For the EB-1A, it's the strategic use is that it's best for those who already have strong recognition or can build towards strong recognition and credentials. For EB-2 NIW, it's useful as a parallel or a backup path for the EB-1A, or really to set an earlier priority date, which I will explain how that works in a different slide. For the green card category, which is, just to let you guys know, you're looking at the EB-1 or the first preference category on the charts. For EB-2 NIW, it's the second category, the second preference category. For the priority dates, what I will tell you is that as of this month, or this upcoming month for August, right, the current priority date for the first preference category for EB-1 is February 15th, 2022. And for China, it's November 15th, 2022. And for EB-2 NIW, you're looking at January 1st, 2013, and December 15th of 2020. You can also check this out directly on the Department of State's website, just to take a look for yourself on the dates, especially if you're trying to figure out if you're abroad or here in the United States. So EB-1A versus EB-2 NIW eligibility, right? So again, what I want to really focus on is that you really might qualify for both. A lot of people who are in the STEM fields do qualify for both, right? So the first thing that I do want to talk about is definitely EB-1A eligibility, because it's going to take the longest, and it's also the one that a lot of you are going to be trying to build up towards, right? So rehashing this again, to qualify, you must show that you have sustained national or international acclaim, and there are recognition of your achievements across your field, right? So what does sustained national or international acclaim means? It means that you've sustained your acclaim over a period of time, right? What the government doesn't like is if you're fresh out of the gate, right? You've had one moment or one set of achievements in a short period of time. It just doesn't feel like you've been at the top of your field for a while, or you have a record or a track record of achievements. It's a little bit harder for people to approach the EB-1A category if you've never really worked, right? So these are, this is a category that's better built for people who do have years of experience working in the field, maybe working for organizations that are out there, and less so helpful for individuals who are just right out of school. But that doesn't mean you can't build towards the evidence that you need for the three categories, right? So I know we relisted this again. A lot of this is just for a brief reminder for a lot of individuals of what the categories are, but I want to walk you through some ideas for each of these categories and how you can invest your time accordingly to get the evidence that you need to work towards an EB-1A. So let's start with major awards and prizes. They're also known as lesser international or national awards, right? In this particular context, I always tell people if it was easy to get the award, it doesn't count. Do not be sold by the Globies, the Stevies, the Titans, and everything like that, where you know that once you pay a fee or once you kind of get enrolled, you will get an award of some format. I have a tendency to basically tell a lot of people, if you see like the terms like silver award, gold award, platinum award, and you're seeing that 100 people have won within the same category, it just doesn't really feel right. Awards should be hard to garner, right? Awards should also be carefully calculated. But to be a little bit more clever about awards, I've been able to argue before that listicles count as awards. So if you have done something and it's like you're listed as top 10 new breakthroughs in XYZ field and you're profiled into it, or your work was referenced into it, and we can prove that it's your work, that could be a really solid alternative opinion to argue, hey, this is kind of like an award. I was awarded that I was one of the top 10 things XYZ, right? Next category is membership in exclusive or achievement-based associations. They should be pretty exclusive, right? Again, it's kind of like the golden rule. If it's too easy to get, if it's something that you can acquire in about a week or two or in less than a month, it just doesn't seem appropriate. A membership organization is truly exclusive if there's a nominations process, if there's an argument that you had to make in order to get into that association. So the more barriers that you had to break in order to get in, the more arduous and rigorous the process is, the more likely that the membership is going to count in your favor. I also will tell a lot of people to avoid memberships that are pay for play. If you have to pay a fee to guarantee inclusion, that's not ideal. Now, membership fees can also be okay, though. It's not abnormal for organizations to charge, whether it's a $50 fee or a $500 fee as part of your dues. Like I'll tell you, I'm a lawyer. Bar associations, they ask us for our dues. It doesn't mean that the bar association is a bad association. It's just that that's part of their money that they need to fund their organization, right? If you can prove that the organization has arduous and rigorous standards that you have to abide by in order to join that organization, then that could still be a relevant organization. I see here a really good question. What about honor societies, right? So honor societies are interesting because they're scholastic. So if the honor society celebrates the fact that you are the best student, right? I forgot the name of it, but like Phi Beta Kappa, I think is like one of them, or one of these like organizations where you're like having a 3.7 GPA. I don't like those ones for the O1 or even the EB-1A because they're not really achievements in the professional realm. They're achievements related to your scholastic ability. So I wouldn't, yeah, that's the one, Phi Kappa Phi, sorry. But I think what I'm trying to say is that those are not really as ideal for memberships in this particular category because it has to be associated with your field of endeavor and not with your scholastic activities. Next one is about published material about you or your work, right? Now, I want to emphasize that it's better that it's about you. The your work part of it is actually a little bit more thin. I would say that if it's about your work, the government really does try to push back, and we do try to argue more as a comparable evidence point if we can strongly prove that it is actually your work that they're talking about. But when it comes to published material specifically, it has to be press, right? Whether it's in trade publications, which are a little bit more limited, right? Or alternatively in major media. But let's be clever about this, right? Don't feel like you need to go on CNN. Nobody's saying that you need to be on CNN or you need to be on Bloomberg or you need to be on anything that's like significant. You could be on something that is very much just relevant to your field. So I'll give you an example. If you are in fintech, financial technologies, right? You're a financial engineer. If you got profiled by a website like Payments, right? Or Finextra, that is equally as valid as a regular CNN article for all I care. Of course, CNN articles in the New York Times are worth its weight in gold, but at the same time, trade publications are easily acceptable as well. Published materials can also be really good if you're willing to invest in it, but I would be careful. There's a lot of people that say, oh, I'm just going to pay for the press. I'm going to hire a PR firm. They're going to guarantee to me that I'm going to be on these publications. Like, let's just randomly call it out. Maybe it's The Guardian UK, Rolling Stone UK, Tech Times. They're basically guaranteeing it. That's a big red flag right there. A PR firm should never guarantee where you're going to be published exactly. It's okay for a firm to say that our contracts conclude after 3 materials are published, right? But to guarantee that you're going to be spotlighted by this organization means that there's some level of quid pro quo, some sort of handshake agreement or payment exchange on the back end for that press. And that's not going to be helpful. The press that the government is looking for is organic media. So the good PR firms, or the ones that are probably the most helpful, are really the ones that, like, let's call it the Hollywood or the entertainers use. But that doesn't mean that they're always going to be ludicrously expensive. They exist out there. A PR firm should function more like an agency. They put you in the right databases for quotes, they list you as an expert, and they try to pitch your stories and your narratives to editors and journalists. 95% of the time, those journalists should say no. They should say that I don't really have the content for this, right? So I would recommend that you consider, right, if you are going to go into published material about you, think about those PR firms, but focus more on organic media, or naturally on your own. You can actually reach out to editors. You'd actually be surprised by how much editors and journalists are actually starving for content, especially for those in topical fields like AI, right? These editors actually don't know where to begin. They're not subject matter experts. You give them a few ideas, you'd actually be quite surprised at how much they want to carry those ideas forward. Next one is judging the work of others. I'm going to touch this one really quickly. 2 main methods for judging that I recommend for a lot of people. If you're in the STEM field, especially in the computer and hardware software industry, hackathons are a really good one. Just don't do scholastic hackathons. I'm not as interested in MIT hacks or the University of Buffalo hackathons. I need you to be judging professionals, and that applies to all competitions. You need to be judging the general public and not students in particular. I see a question here. What about judging others, but in a different field? I would tell you that the government allows you to make the argument for an allied field. So I'll give you an example. If I have a mechatronics engineering degree, or if I have an engineering degree in electrical engineering, that's still applicable in a hackathon context or in any other hardware context. It's technically a different field. However, it's an allied field and one that I can easily argue for. Yes, this is recorded for later viewing. We will be providing a lot of this material accessible, whether it's through our socials and on our website or on our YouTube channel and on Instagram. So please wait for that as well. Second method for judging is peer review, guys. Peer review is a really, really solid way to garner judging materials because you are judging the scholarly work of others for journals, right? You guys need to be in databases. I think they're called CMT or CMA databases. What you need to be doing is joining associations. A good example is IEEE. Now, I want to caveat this. Don't join IEEE just for memberships, right? If you make it to fellowship level, then great. But if not, you're joining IEEE to become a senior senior member so you can assess other people's applications, especially if you're in the STEM field. But really what you're trying to do is get access to their conference database, right? So you can start peer reviewing materials for those conferences and their own journals, right? IEEE is a real organization, but there's many other associations that are out there. That's just like one example of multiple, right? Yeah, judging others doesn't mean the gossiping you do with your friends in the local cafe. I'll make that very clear. You're judging people's materials. So moving on to original contributions of major significance. So this is harder for me to tell you how to invest your time in, right? If anything, it's more so me trying to remind everyone that this is actually the hardest category to meet. However, if you do meet this category, it's actually a really good litmus test for us attorneys to determine if this is going to be a really good case, right? Because if you manage to prove to an officer that you did something that was so novel and so incredible that it was absorbed in your industry, it's really hard for them to kind of counterpoint to that you're not extraordinary within your field, right? So when it comes to original contributions of major significance, I'm going to break it down into two parts. It has to be original. Has to be novel, has to be yours. It could be an applied methodology. It could be that you changed a methodology that was out there, made it yours, and it had an impact. That's great, but you need to prove that you were an originator, right? Second to that, when it comes to major significance, you should be really pushing towards whether or not your work had an impact, right? Good example is patents. Patents alone prove that you have an original contribution. If you're an inventor on it, that's original. If it's a patent, by virtue of it being a patent, it is also original. I think I might have lost everyone. Oh, can everybody hear me? Okay, so I'm gonna just assume that everybody can hear me. My screen paused, but okay, let's continue, right? So I think what I was trying to say is that if you have patents, it proves that that itself is original. But to prove that it's of major significance, usually us attorneys would take a look. The video is frozen. Usually we would essentially take a look at patent citations, right? So the way that patent citations essentially work is that you would take a look at who is using what. So sorry guys for the technical difficulties, not sure what happened here. But essentially with patent citations, you can actually see what other organizations or what individuals actually utilized your patent or derived from your patent. That derivation is a really good way in order to show to the government that your work has had a significance in your field, right? So noting that again, a really good attorney would be one that would dive into those topics very deeply with you in order to determine whether or not you can prove major significance. Going to touch the other ones really, really quickly for the interest of time, right? I will also let you know that there is another public webinar where I talk really deeply about evidence development, what kinds of evidences work really, really well for kind of individuals in different fields. So we would be happy to share those links as well for everybody to view. Touching on authorship of scholarly articles, this is where I tell a lot of people, leverage your network, reach out to your professors, reach out to people in academia. People who reach out to academia and the people that they know there, you'd be surprised at how many connections that you can make to become a co-author or a main author, even for a research project, right? They have the right connections that you need in order to do what needs to be done. Give me 1 second. Can you still hear me? Okay. So we can hear me. Oh, people can't hear me. Oh, can people hear me now?
Okay, let's see. Did you removed yourself from the stage?
No, but I put it back in. I think somebody put me back in. I think you guys can hear me now, right? I think I've just been talking into the ethos.
Oh, yeah.
Okay, all right. So you guys are just gonna see me close my eyes the entire time. Sorry about that. We're gonna figure out like what happened with the video. But at least when you guys can hear me, rehashing for high salary, high remuneration, it's a calculation. I try to tell people, let's focus on trying to get 200K if you're here in the United States. But if not, an attorney should make the analysis to compare you to the Bureau of Labor Statistics for your particular occupational code. Separately, when it comes to individuals who are abroad, you'd be surprised at how much your government does have these statistics. You might need to look at government databases, so be it. I would recommend that you take a look at your government websites to see what kind of labor statistics that they have to compare your salary in, right? When it comes to commercial success in the performing arts, I want to emphasize that these are only for the performing arts, guys. So box office receipts, things that are tangible to a very specific performance is going to be ideal. And then when it comes to exhibitions or showcases of your work, very good that my integrated camera doesn't work. Yeah. So the exhibitions or showcases of your work, this is only for artistic exhibitions, but UI UX designers out there, right? And also industrial designers. I had a really wonderful case once that I was pleasantly surprised to hear that there are gallery showings and there are events that try to showcase UI UX work. Guys, we're living in 2025, right? Virtual galleries, novel versions of what it means to be creative in your field is brand new. I even had someone before who does like medical drawings, right? Like that's like really more of a scientific role, but there was a gallery aspect to it. There was a special event and we still made the argument anyways, right? So you'd be surprised again. You might find something that's out there that could be artistic in relation to your work that you can display, right? Oh, I did miss leading role in the distinguished organization. Sorry. I think like part of it is because we're trying to fix the camera at the same time. For leading role in distinguished organizations, I want to make sure that we understand it's lead or critical role. So it's so long as you are holding a leadership position or you are holding a critical position, if not both, at an organization that is arguably distinguished, the government likes it. I think what people have a tendency to overlook is that distinguished organizations is actually a very thin line, right? It just means that I need to be able to hook, as an attorney, hook them onto something, right? What makes that organization that you are working for distinctive from another organization, right? What makes it different, right? So if it's different enough from the general public, hey, everyone, I think we have a backup camera, so hopefully everyone can see it, right? Then that would be extremely helpful for an EB-1A application. So I'll give you an example is that if you're a startup and you're backed by a really, really big investor, like a big founder, even if your startup is relatively new, that could be a way for us to try to argue that your organization is distinguished from someone else, all right? For percentile for high salary, I will tell you that my demarcation line has always been to be in the top 10%. Thank you everyone for your patience. So I know that this camera is very zoomed in comparison, but here I am again. So I wanted to kind of like, actually before I go into EB-2 NIW, last point guys for EB-1A, it's more is not always better, right? Don't feel like you have to cast the widest net and meet all 10 categories. If anything, quality, impact, and narrative clarity matter the most, right? Invest your time in like 4, maybe 5 categories, right? For many of you, you might already meet like 1 or 2, right? So rather than investing your time into building like every single category out there, to choose like 2 or 3 more, right? You only have so many hours in a day. So try your best to kind of focus your energy on the right places, okay? So going into EB-2 NIW, I would say that this is the eligibility test. It's a 3-pronged test. It's something known as the DANASAR framework. The DANASAR framework, I'm not going to touch too strongly on it because it's pretty straightforward. So I'll just come through it. Substantial merit and national importance. Your work benefits the U.S. in science, technology, health, business, or areas that the government has deemed to be of national importance, and there's merit to the argument that you are making. Second thing is that you're well positioned to advance the work. education, track record, and impact in your field that support continued success, right, for your ability to push that endeavor. And then there's a balancing test that it's in the US's interest to waive the normal job offer and labor certification process. That is a good question, Rocio. Are publications required for the EB-2 NIW? The answer is no, although they can be helpful, right? Because it has to do with your track record and your positioning on whether or not you're able to advance the work, right? So I'm not going to talk about like how you can meet every single one of these prongs. Instead, I'm going to tell you guys like the ideation behind it, right? What are some good ideas, or what are the things that you need and the tools that you need to kind of rely on to make a good EB-2 NIW case? Every consultation that I've ever done, I've always told every single client, take a step back, look at your industry and look at the news, look at what the US government is dealing with, and think about a problem statement. What is a problem statement that the US has? So I'll give you one that I tell a lot of people, which is the US is really worried about cobalt. There is an over-reliance of cobalt in the battery industry in China, essentially. The US has to trade a lot with China for cobalt. It's actually a really big trade-related issue, because if our relationship does sour, we're going to have some serious problems in kind of delivering the batteries that we need to function here in the United States, right? So that is a problem statement. Now you have to think about it yourself. If you're a battery engineer, right, what can you do to solve that problem? Right? Are you developing batteries that don't require cobalt, right? Are you maybe, let's take even a further step back. What if you're a scientist that's trying to determine, right, what are alternative versions of cobalt that we can make? Or maybe you're trying to make mining cobalt in the United States easier, or something even crazier. You're a broker. You're a broker, somebody who connects the US government with cobalt suppliers in other countries who may not have those connections, right? So in many different ways, I would tell you that there's a lot of things that can be quite creative when you start first with a problem statement and how you can provide a solution to that problem statement. And once you kind of put those two things together is how you can develop the rest of the answers for the three-pronged test, right? So substantial merit and national importance, the problem statement is that the government has a problem with XYZ, or the United States has a problem in XYZ. Right? When it comes to well-positioned to advance the work, if you're a battery engineer, what is your track record before that? Have you developed similar tools? Are you working in the industry that would be developing similar tools? Do you have the right education as well? And then when it comes to the balancing tests, I would say it's more of a domino effect for the first two, which is proving the fact that the government needs it so much, or it's in the US's interest to waive the normal green card processes, waive the fact that you need a job offer because the US needs this so bad, right? I will tell you that the EB-2 NIW is really ideal for researchers, innovators, policy experts, public interest professionals, because it's so tied to that ecosystem of the US's interests, the public's interests here within the United States, right? Pro tip of the day, USCIS looks for evidence of potential but not perfection. Show your trajectory and why your work matters now, okay? So filing strategically, guys, this is kind of the crux of why we're talking about EB-1A and EB-2 NIW together, right? If you qualify for an EB-2 NIW first and need more time to work on a potential EB-1A, then focus on getting the EB-2 NIW first, right? Sometimes if you're already qualified, put together the application, file it, and if you get it approved, now you have an earlier priority date. Why? Because the time of filing and then getting it ultimately approved sets the priority date. Once approved, you can then file for an EB-1A if you're at that stage in your life at that point and you're able and capable to file for it, right? To absorb the priority date that was set by the EB-2 NIW, right? So that previous I-140 is what sets that priority date, and it can be absorbed in the next priority date. Also, if your employer is willing to take on a perm, allow them to do so in order to cast a wide net. Perms don't hurt anybody, right? If the company's going to do it for you, you might as well do it. Remember my stove analogy, you should have multiple pots going for you, going at the same time. If you have the resources, nothing prevents you from trying for both concurrently. If you qualified for both and you want to throw the kitchen sink at the wall, remember, talk to counsel first, talk to us first. I would never want you to throw the kitchen sink at the wall, as I genuinely believed that you were had a meritorious case for both, or you qualified for both, because it doesn't really make sense to me. I would rather get you to the end goal of your immigration journey, which is that approval and having that green card in hand at some point, rather than just throwing anything at the government. Right? But it's a really good reminder that the government doesn't prevent you from doing that. Good question. What is a perm? A perm is a labor certification process where an employer can prove to the government that there's no U.S. workers available to fulfill a permanent position in the United States, right? So how does this impact you as a foreign national? Essentially, the company is saying, I need to sponsor this person for a green card, and that's because no one else can fulfill it. It does take a bit of time for it to conclude. However, a lot of companies do provide this to their employees if they want to keep them around for long term. So if they offer it to you, you might as well take it, right? Next thing is having both the EB-1A approved and the EB-2 NIW approved can provide you a timing benefit and coverage regardless of changes to either case type. For example, I can't control the fact that if the government decides to make the first preference unavailable, right? That means that you can't adjust anytime soon. But if EB-1 is unavailable, you're still in the clear for EB-2, the second preference category, because you have an EB-2 NIW approved. So keep that in mind. So why does any of this matter? Why does exploring alternative green card pathways matter? It's because it has to do with your family, your freedom, and your future, especially here in the United States. When it comes to your family, spouses and children can benefit from faster approvals. I know many of you, or many who have come to us, who are worried about their children who are here on dependent visas. They're 14, 15, 16, right? What if they age out before I can get a green card in hand, right? That is a real legitimate question, and that's why you need to be looking at possible other categories that can accelerate your pathway, right? Another thing is that you have more control over your career path. Many of you are on employee visas where you feel very stuck. I have no choice but to devote myself to this specific employer because I'm bound to their programs, right? When you have those approvals, especially I would say like an EB-2 NIW and an EB-1A, right? All of a sudden, that request of having a perm done or having like these green card supporting benefits is not as painful when you want to change companies. For those of you who are very familiar, if you're on an H-1B, of course, you can change companies by transferring. But if you only have an approved perm, that new company that you work for would have to restart the process in order to let you get the benefit of having a green card in the long term. But if you have your own green card approval, like an EB-2 NIW or an EB-1A, that's less of a consideration, right? Ultimately, a green card gives a lot of people peace of mind and a lot of years of, after years of a lot of uncertainty, right? Give yourself that level of certainty, take control over your own destiny. That's the reason why we're called manifest, right? We're here to manifest our hopes and dreams here, whether it's in the United States or not. But the reality is that you can manifest your future here in the United States, especially with the right investment and the right tools and thought process. So I want to give an example of what all of what I said looks like in practice. I had a client who held a head of product role at a healthcare accessibility company, right? A lot of their work had to do with designing protocols, programs, and software that allowed people to access their healthcare benefits, right? There was some strong cases for both the EB-2 NIW and the EB-1A. Guy was paid very well, he was in a leadership position, and he was willing to invest time into doing thought leadership, getting published out there, and being interviewed, right? So the strategy, though, is because he immediately was more qualified for the EB-2 NIW, we decided to focus on that application first and get it filed. And in the meantime, gave the client the resources that they needed in order to strengthen their EB-1A profile with additional achievements, right? By the time we filed that early EB-2 NIW filing, it advanced the priority date by a year because we filed it, and then 1 year later, he was ready for the EB-1A. It actually provided the guy a lot of peace of mind. The EB-2 NIW approval offered security. It enabled the client to start their own company and attract the funding with the green card pathway confirmed, because they said, you know, no matter what, I will end up with a green card at some point, maybe not now, but in the future. However, when we filed the EB-1A, we were able to secure the priority date, and ultimately the guy got approved and now is in the middle of the adjustment process, right? So what I will tell you is that they wouldn't have been able to be to have the ability to file the EB-1A if they didn't have the priority date secured to get that adjustment of status in. So sequencing both petitions really maximized both the timing advantage and the overall case strength. So yeah, that was really it for the presentation. Now it's kind of like the Q&A time, and I'm more than happy to answer some of the questions here that I see on the comments. I may not answer every single one. For those of you who ask very, very personal questions, what I want to say is that this Q&A is not supposed to replace a consultation, right? It is not a one-on-one call with an attorney, right? So if you want very specific legal advice, please don't hesitate to use the link in our socials, in our bios, to kind of schedule a consultation with us. Right now, we are providing free consultations for individuals who are interested in talking to us, especially if you met us through the webinar. So please don't hesitate to reach out to us to get this free consultation. We will evaluate your profiles and we'll have a conversation with you about what we feel you can qualify for and what resources that we can provide to you, right? So I'm going to try my best to kind of find all of the questions in the beginning. I see one that has to do with pending asylum, right? I will tell you that the crux of the question is, if I am approved for EB-2 NIW, will I be able to adjust status, right? Honestly, that's a very complicated question. I'm not going to lie to you. For the most part, especially in the current administration, I would not think that you would be able to, right? But I will say that this is a state-by-state issue because it depends on the existing district decisions in your area. The other thing that I will also mention is that timing is part of it. I need to know when you filed for pending asylum, if you're at the affirmative stage or the defensive stage. Let's see here. Next one is, I heard quite a lot of rejections these days on EB-1A. I will tell you that the most recent statistics, it's been relatively stable and not too different from the previous, the end of the last year's administration, right? But what I will tell you is that I think things are getting a little bit harder, and a lot of the focus has to do with what is known as final merits determination. Are you truly someone at the top of your field? That's where a qualified professional like an attorney should be able to jump in and advise you on some of the things that you should be doing and focusing on to try to overcome that question. Meeting the 3 criteria is one thing, but really proving to the government your sustained claim that you are somebody in the top of the field is something that's going to be very important for these newer applications that are going out. Next one, what are good awards to include in EB-1A and how to check good journals to publish papers? You know, for good awards is really tough. Like, I really will tell you that it depends on your field, but I actually think I have a better answer to your second question, is how to check good journals to publish papers, right? It's actually checking for bad journals where to not publish papers, right? That's the big thing. There's something known as the Beals list. So it's B as in Beverly, E as in Echo, A as in Alpha, double L apostrophe S, right? The Beals list has a list of something known as predatory journals. You want to avoid a lot of those journals because the government has been flagging them recently. Don't invest your time in those. Try to find either newer or alternative journals. And also don't forget, trade journals are also acceptable as well. Again, reach out to your academic network, former professors, graduate research assistants, because they're built into that system and are scholars. They usually have a lot of good connections on how to get you journal publications. Going through, there's a lot of I can't hear you, so thank you about that. Does Manifest support profile building? So profile building is an interesting concept, right? I want to say that what we do is better suited for evidence development, right? Not every single person is close enough to the sun, right? Not every single person is close enough to get to the point of an EB-1A. We do have resources and we do provide a service where we try to help people kind of get to the end goal, but we're not here to apply for journals for you. We're not here to write these scholarly articles for you. It's more so that we're giving you resources in matching you with the right opportunities to support your application, right? We do have something known as the Manifest Opportunity Matching Program. It's not for every single person. We would do a consultation and we would determine whether or not you would be a good candidate for it, right? We are not profile builders. We focus 100% on developing good evidence, right, within ethical standards and what the government is looking for. Next question is, can you do a profile review? I won't be able to do it by today, but I can do a profile review. A lot of our team members can do profile reviews. We have a large network of over 30 vetted attorneys to join the Manifest Collective. It's actually harder to join us than to go to Harvard, right? We really do a lot of strong vetting processes to make sure that we have some of the best attorneys that are out there to work on these applications, right? Now, let me see here. Will you apply EB-1A for F1 PhD? Depends if you had a career, right? Some people who come to the United States on a PhD have had 10 years of a career before they came to the United States on a PhD. But I will tell you, you will be trying to overcome a case of first impression. The officer will always think, it feels like, you're just a student right now. Prove to me that you're now at the very top of your field. So it really can depend, right? And then let's see here. If I want to explore, say, EB-1A and NIW, will the charge be twice for you? I will tell you, remember that these are two separate applications, but the charge would not be twice. We do provide volume discounts for individuals who are interested in pursuing both, but we try to be very fair with our clients. At the end of the day, if you qualify more for one than the other, and we don't believe that you would qualify for one of them, then we're going to tell you that, because we would rather focus on working on the one case that is better for you. Can I apply for the EB-2 outside of the USA? The answer is yes. There's nothing preventing you from doing so. However, you should talk to your attorney when it comes to timing. Some countries have it easier than others when it comes to finishing off the process. So if you have an EB-2 NIW approved and then you're telling me, hey, how long do I have to wait until I can go through the consular processing? It actually can depend on your country of birth and where you are. Can you travel outside of the US after having the priority date and before and after the current date? So this is actually a very specific question. I would need to know like what visa you're on at the moment, but let's take a step back. If you have a dual intent visa and you're here in the United States on an H-1B or an L-1 and you have an approved I-140, it's not really a problem. You can travel wherever you want. And even if you have a pending 485 based on it, you can actually travel when you have an H-1B or an L-1, right? For other visas, you need to wait for a travel authorization document, because if you leave the country while an adjustment of status is pending for you, you will abandon that adjustment of status. So be careful about that. When it comes to, there are rumors that premium processing for NIW can lead to a higher chance of RFE or denial. Do you believe it to be true? Rumors are rumors, but what I will tell you is that let's focus on logic, right? If the government has essentially halved, right, or close to halved the number of workers working on cases like at USCIS, right? And we all know that there's been an increase in the number of cases that have been filed in the last year, right? And now we impose this really, really hard deadline on them adjudicating the cases. It can lead to scenarios where an officer doesn't really have a choice but to issue an RFE because they have to do something by that date, or alternatively refund the fee, right? They do try to avoid having to do those refunds. I can't prove it. A lot of it is anecdotal evidence, right? But there are ways to compromise on this. Sometimes for some clients, depending on the case, I would tell them, like, let's start with regular processing because you can always upgrade to premium processing in the future. Next one, let's see here. Does being an ex-member of a council count? Depends on what the council is, right? It could be an ex-council, but if you were a member of it, you were still a member of it at some point, right? What about EB-1A for chef with 6 years of experience and a chef professor recently graduated? Depends where you were a chef at. Actually, funny enough, I used to be a chef back in the day. Before I decided to go to law school, I decided to work as a chef for a while. It was a very interesting experience, a very interesting field, and I think it gave me a lot of discipline for sure. I would love to take a look at your profile. I think creative in EB-1As are probably one of the more nuanced applications, right? So let's see where you worked, what you've done, and then we'll go from there. How about conference program committee membership? I know that I keep saying it depends. It's a very lawyer answer. It depends on the conference program. Like, how prestigious is this conference? I have no idea, right? The more prestigious the conference, or the more exciting the conference is, or the more brand value the conference is, the better it is. Let's see here. Fashion designer can also be eligible for EB-1A. Depends, right? It depends. Like, what kind of commercial success do you have? What kind of exhibitions have you had, right? Where has your work been displayed? Were you part of like a Vogue collective, right? Vogue has like these really interesting individual events that occur throughout the United States where they showcase the latest and greatest for designers. That can technically be an artistic exhibition. Let's see. Any examples for those organic PRs? We do have some resources, but you should reach out to us for a consultation to see if you're suitable for those resources. Okay, there's a lot of questions coming in. I'm going to try my best to answer as many as I can. For a scientist, I heard of 10 publications, 10 peer reviews, 100 citations as success criteria for EB-1A. Is that true? Yeah, I don't want to say it's true or not true. I think it's just that there's no such thing as a bright line rule. It's up to the officer to decide whether or not it's relevant within your industry, right? I think that the number of citations is less of an issue if you're in a very practical field. I feel like engineers get a lot of pressure to get citations for no reason because citations are not really normal in your field. However, if you're a biologist or you're a chemist, like in the natural sciences that are known for research activities, then the burden of having a lot of citations is much higher. What about judging the work of colleagues? Oh, that's an interesting one. I think if you have an outside, if you have a committee within your organization and it's not necessarily an interviewing committee, it's a reviewing committee for certain types of applications, there is a way to make the argument, but that's fine. Very quickly, why are the comments appearing on the screen? Some comments are appearing on the screen. They really shouldn't be appearing on the screen. I just want to make sure. Next one is, can the citation be from work you published in the past? I have a 2020 publication with over 100 citations. Yes, it can. And the past is not that long. I know 2020 is technically 5 years ago. Man, it's been 5 years since the start of COVID, right? I think what I would like to say is that I think that's recent enough to be relevant. Does being in a Fulbright panel selection, does it count as judging the work of others? I think what you mean is that if you are part of a panel to choose other people to become Fulbright scholars, that seems pretty prestigious to me. Right? The only thing that I'm concerned about is that traditionally Fulbright scholars are students, they're young, right? But it's a Fulbright. I think I would try to make the argument for sure. In the absence of a high citation count on a manuscript, which other criteria can be emphasized to showcase your proficiency or impact? Well, let's remove high citation count for a second. If you published a research paper and you feel that you can prove that it had an impact within your field, whether it's through letters from other industry professionals who use your work. I try to use this a lot with engineers because, again, if you did something really cool in engineering and you published about it, it's actually very rare that you would get a citation, because if another engineer saw your work, they would just apply it in a very practical setting, right, in their own jobs. So I usually try to get people to connect with those engineers or other people within their fields to say, hey, have you used my methodologies? Have you seen my work? And if you did see my work, how did you use it? Were you be willing to affirm that you used it? Okay. Should foreign salary history be higher than the US equivalent, or is it compared with a specific foreign location? It's the latter, specific foreign location. I mean, no matter what, the best evidence will show both, but the reality is that it's supposed to be compared to others within your field and your geographic location. Can we change employer once EB-1A or EB-2 NIW is approved, or will it affect my case, right? You can if it's self-petitioned in either scenario. The one thing I will say is with the EB-1A, remember, you have to continue that, sustain the claim. No one is saying that you need to keep investing more into each of the criteria. It's more so that, continue being incredible, continue being extraordinary within your field. For the EB-2 NIW, it's more so that you should be still within your field. Like, you don't want to tell the government, I'm going to be a civil engineer working on FEMA projects. And then by the time you decide to adjust, you're now a graphic designer. Like, I would not be very happy with that. You want to try to stick to your same field. Would the current political environment change the priorities of the U.S. for the NIWs, like less focus on clean energy, vaccines, etc.? Yeah, I'm going to be very honest with you guys, right? I think that, the priorities have definitely changed. I would go back to what I said earlier. You guys need to find the current problem statements of the government, not the past problem statements, right? Problem statements change, priorities change, right? So sometimes in the past, we used to be able to make really good cultural arguments, right? Like improving culture, like fighting against certain types of marginalization. I feel like nowadays the priorities have really shifted more into scientific innovations and innovations generally speaking. What can make America much more competitive in its environment? That's something that I would definitely consider more for. Okay, so we're coming to a close to our time because unfortunately I do have to go, right? I know that a lot of you have so many different questions, and I really do try to set aside as much time as possible for them. But remember, we do provide free consultations. Please don't hesitate to reach out to us if you want some of these questions answered. We're more than happy to support you guys any way that we can. Okay? All right. So thank you, everyone. And you guys will be getting some information from us. And this webinar has been recorded and will be published. Take care. Thanks, everyone.